Namaskar. Good morning to one and all. I, Kiran Singh, Assistant Professor, Institute of Legal Studies, on behalf of RAMSWAROOP University, welcome you all on the second day of National Seminar or webinar on the very relevant topic that is IPR and impact of COVID-19 on law and society. In today's session, it's a matter of great privilege and honor for us that today we have with us two eminent experts on IPR and international law. In the first session, on the second day, we would be having first speaker as Professor Dr. Yashwant Singh, former Dean, Faculty of Law, Dr. Ram Manohar Lohia, Awadh University, Ayodhya. He would be delivering his view on impact of COVID-19 in the globalized world. And the second speaker for the second session would be Dr. Amren Kumar Ajit, Assistant Professor, Faculty of Law, University of Delhi. He would be covering the international aspect of the same, that is COVID-19 and international law. Dr. Singh, Dr. Yashwant Singh is an eminent professor in the area of international law, having versatile experience in the field of international law, company law, and Muslim law. He was the former dean of head of faculty of law, Dr. Ram Manohar Lohia, Awadh University, Faizabad. He was also the former principal of KNI PSS Sultanpur. Presently, he is the coordinator of Kamla Nehru Group of Institution. He is a man with tremendous experience in the field of law. I extend a warm welcome to you, sir, and request you to share your view on the very relevant topic that is impact of COVID-19 in the globalized world. We welcome you on the behalf of SRMU team, sir.
Honorable Dr. Rakesh, Vice Chancellor, Dr. Mohan Atara, Director, Ms. Kiran Singh, Assistant Professor, Dr. Sudhir Awasthi, Convener of the Seminar of SHRI RAMSWAROOP University, Varanasi. I have been directed to deliver my lecture on COVID-19 and its effect on international law. It's a global effect. You know it well that we are living in a new era of internationalization, era of globalization, era of marketization, era of privatization. Indeed, we are living in a new world, completely changed world, completely different from the old world. And this change has been brought under the influence of science and technology. Although change is the law of nature, but the scientific development and technological advancement in the present century has witnessed the ever-accelerating rhythm of change. Now we are facing the unprecedented speed of change and dynamism. They have unleashed the social, political, and economic pressure of the world. This unprecedented speed of change and dynamism has sometimes compressed to inquire the matter whether law can keep pace with the life. And sometimes it is argued that law is going to become less important and practical action going to be more important. It is true not merely about the municipal law but also about the international law. It may be minus point for municipal law, but I think it is a plus point for international law because theoretically international law is very weak law. Theoretically international law is not codified law. Theoretically international law has no any legislative machinery to enact it. Even today it depends upon the customs and treaties concluded between the civilized states. Theoretically, there is no sanction behind international law like the municipal law. International Court of Justice has no compulsory jurisdiction. In spite of all these weaknesses, the situation has arisen in such way as to observe the laws of international law practically. It is not possible for any state, it may be developed, developing, or undeveloped, to keep itself aloof from the family of nations. Now there is nothing like distance. The international transportation and communication have reduced, minimized the distance. There is nothing like distance. Entire world has become a globe. We are just facing the concept of global village. सब एक दूसरे के करीब हो गए, एक दूसरे के नजदीक पड़ोसी जैसे होके रह गए. One thing more, it is not era of complete independence. It is an era of interdependence. Socially, economically, politically, all the states are interdependent. Indeed, it is in the common interest of the world society, whose number is proliferating nowadays, to institutionalize the social, political, and economic interdependence and to ensure continuing cooperation in different areas, particularly in the areas like the continuation of international peace and security, elimination of race power, prevention and punishment of international crime, exploration and exploitation of natural resources, prevention of pollution, and so on. So all these fields of interdependence of the states, which is the necessity of the day, international transportation and international communication, international trade, and international intercourse in other fields, have undoubtedly strengthened the value of international law. Theoretically, it may be a weak law, but practically, it is now effective law. And it happens so only because of the concept of global village. एक वर्ल्ड गवर्नमेंट की हम कल्पना करने लगे हैं, दूसरी सरकार की एक दूसरे के नजदीक आ गए हैं करीब आने. हालांकि ताजुब है, जहाँ संसार की दुनिया मिल गई, वहाँ एक इनक्यूरेबल डिजीज ने सोशल डिस्टेंस पैदा कर दिया, जिसपे हमको आपको बोलना. जहाँ हम इंटरनेशनल लॉ के द्वारा गवर्न होने लगे थे, वहाँ पर्सनल इंटरनेशनल रिलेशन जहाँ हमारा प्रिय विषय हो गया था, वहाँ पर्सनल रिलेशन भी बड़ा इम्पैक्ट रख दिए गए. हालात कुछ ऐसे पैदा हुए. देखो ऐसा है ना, विज्ञान और तकनीकी के विकास में केवल दुनिया को समेटा के छोटा सा ग्लोब नहीं किया. हमने चार तारों की दूरी ही नहीं नापी, बल्कि उसके कदम भी रख दिया है और हर देश को एक दूसरे करीब ला दिया. दुनिया के हर देश एक दूसरे की आवश्यकता महसूस कर रहे हैं, बल्कि सोच में भी अंतर लाया, विचारधारा में भी अंतर लाया. इज और आर्ट का कॉन्फ्लिक्ट पैदा हुआ. इज मीन्स दिस इज रियली गोइंग ऑन. इज मीन्स दिस इज विच इन फैक्ट एग्जिस्ट. आर्ट मीन्स विच आर्ट टू बी, विच शुड बी. जो साइंटिस्ट है ना, जो वैज्ञानिक है ना, वो पॉजिटिविस्ट अप्रोच में विश्वास करता है. वो कहता है आई बिलीव इन इज, दिस इज रियली गोइंग ऑन. व्हाट आर्ट टू बी, व्हाट शुड बी, इट इज वेरी हाइपोथेटिकल अप्रोच, इट इज फिलोसफिकल अप्रोच. एक तरीके से नेचुरलिस्ट पॉजिटिविस्ट के द्वारा पीछे धकेल दिए गए. और इस पॉजिटिविस्ट का जो डोमिनेशन हुआ, मैं डिटेल में नहीं जा रहा हूँ, संक्षेप बता रहा हूँ. Mainly because of domination of positivist approach, we come to two devastating world wars, First World War and Second World War. After First World War, League of Nations was established. जिसका उद्देश्य था to have the peaceful settlement of international disputes, but this league failed in its object. अब यही कारण था कि द्वितीय विश्व युद्ध हो गया, ये अपने मकसद में कामयाब नहीं हो पाई. सेकंड वर्ल्ड वार हुआ. सेकंड वर्ल्ड वार वर्ल्ड वार इन टू सेंस ऑफ द वर्ड. दुनिया के तमाम मुल्क इसमें शरीक हुए, लाखों लोग मारे गए. खुद हिंदुस्तान के कई लाख लोग मार दिए गए. जीनोसाइड कमिटेड ड्यूरिंग द वार. जीनोसाइड कमिटेड ड्यूरिंग द होमोसाइड कमिटेड ड्यूरिंग द वार. वार क्राइम कमिटेड ड्यूरिंग द वार. Crime against the humanity committed during the war, crime against the peace committed during the war, इतना अपराध हुआ, इतना खून रहा, इतने लोग मारे गए और विशेषतया नागासाकी हिरोशिमा में युद्ध हुआ। यद्यपि जापान ने घोषित कर दिया था कि हम समर्पण करने जा रहे हैं, इसके बाद भी अपनी धौस दिखानी थी, अपना रुतबा दिखाना था, अपनी ताकत दिखानी थी। बना दिया था एटम बम, किसको दिखाते, गिरा दिया बेवजह नागासाकी हिरोशिमा पे, सब कुछ जलकर स्वाहा हो गया। जो कुछ घटित हुआ पूरी दुनिया कर रहा। ये जो पास्टिस्ट थे ना, जिनकी पास्टिस्ट सोच थी, वो बहुत पीछे चले गए, फिर उठा के नहीं, जीवन का कोई आदर्श होना चाहिए, कोई लक्ष्य होना चाहिए, कोई संस्कृति होना चाहिए, कोई ब्रह्म नाम होना चाहिए, जीवन का कोई आदर्श होना चाहिए। अंथा तो समस्त मानवता ही खतरे में पड़ गई। आज जैसे मानवता खतरे में पड़ी हुई है, यही दौर उस समय था। और उस समय देखो, रूजवेल्ट अमेरिका से, स्टालिन रशिया से, चर्चिल इंग्लैंड से, फ्रांस से, पीवी सुंगा चाइना से, ये सब के सब मिलजुल करके प्रयास करना शुरू किए कि अरे भाई साम्राज्यवादी लीग खत्म करो, इक्वल कॉन्सेप्ट पर चलो, सबको आजाद कर दो और एक अंतर्राष्ट्रीय संगठन को बनाओ जो राज्यों के अनगिनत पावर पर उनकी सॉवरेनिटी पर बंदिश लगा सके, विश्व बंधुत्व का भाव लाओ, ब्रदरहुड को डेवलप करो, जिसकी परिकल्पना हमारे यहाँ बहुत पहले की गई थी, वसुधैव कुटुंबकम के रूप में। फिलहाल विभिन्न कन्वेंशन के द्वारा, विभिन्न सेमिनार के द्वारा अपने चलते चलते उसमें में नहीं जाता। 24 अक्टूबर 1945 को यूनाइटेड नेशन चार्टर साइन कर दिया। आप जानते हैं कि इट वॉज साइन बाय 51 स्टेट्स। ये वो वक्त था, यहाँ इतना भी जानना जरूरी है, वक्त था when most of the Asian African countries were under the suzerainty of European power. जो 51 आए थे, यदि ब्रिटिश इंडिया वाज आल्सो वन ऑफ देम। होना तो चाहिए था ब्रिटिश इंडिया को मेंबर, होना ही नहीं चाहिए था, लेकिन इंग्लैंड अपने वोटिंग पावर को बढ़ाने के लिए, इंग्लैंड की इतनी धौस थी कि गुलाम होते हुए भारत को सदस्य बनाए, कोई भी बोल नहीं पाए, क्योंकि इतनी धौस यूरोपियन पावर इतना डोमिनेट कर रहा था। दूसरी बात, हमें आपको बताया जाता है कि all the civilization of the world, Hindu, Muslim, Jew, Christian, they all have equally contributed in development of international law. But जो इंटरनेशनल लॉ जानता है, जो पढ़ा है, वो अच्छी तरह जानता है that the different branch of jurisprudence, the system which we know today as international law is modern and dating back to the 16th and 17th century only. For its special character has been determined by those are European state system which was itself shaped in the ferment of Renaissance reform. 30 साल युद्ध चला था यूरोप। याद होगा 1648 की वेस्ट इंडिया की युद्ध समाप्त हुआ था, एक फैमिली ऑफ नेशंस, यूरोपियन फैमिली ऑफ नेशंस बना था, वही बाद में कन्वर्ट हुआ लीग ऑफ नेशन में फर्स्ट वर्ल्ड वॉर के बाद। उसी का एक बदला हुआ स्वरूप यूनाइटेड नेशन ऑर्गेनाइजेशन के रूप में आया सेकंड वर्ल्ड वॉर के बाद। इसमें यही एक कारण है कि एशियन एंड अफ्रीकन कंट्रीज आर जनरली रिलेक्टेड टू एक्सेप्ट इंटरनेशनल लॉ। सर फैक्ट छोड़िए, इन बातों को नहीं जाता। यूनाइटेड नेशन आया, कुछ उसकी बातें बहुत अच्छी रही। इट इज बेस्ड अपॉन द सॉवरेन इक्विटी ऑफ द स्टेट irrespective of geographical limit, population, power, prosperity, poverty, although NATO is here to fight the states, no doubt. कहा गया कि वो सोशल इकोनॉमिक कल्चरल पॉलिटिकल मैटर एक दूसरे को कोऑपरेट करेंगे, फ्रेंडली रिलेशन डेवलप करेंगे। हम वही बोलते हैं कुटुंब का भाव, हम अंतर्राष्ट्रीय स्तर पर सिक्योरिटी लाएंगे। ये कहा गया कि वेयर देयर इज ब्रीच ऑफ पीस और थ्रेट ऑफ पीस, इतने नहीं, इफ देयर इज अप्रेंशन टू ब्रीच ऑफ पीस और थ्रेट ऑफ पीस, सिक्योरिटी काउंसिल एक्शन लेगा। जैसे वो सब आप जानते हैं। ये बहुत बड़ा और सबसे बड़ी बात है कि यूनाइटेड नेशन चार्टर का प्रियम्बल जो शुरू होता है, कहता वी द पीपल ऑफ यूनाइटेड नेशन। वहाँ स्टेट का नाम नहीं है, वी द पीपल ऑफ यूनाइटेड नेशन। I mean to say, man is at the root of every law, whether it is municipal law or international. Law is enacted only for the welfare of the man, welfare of the human being. यह और बात है कि इंटरनेशनल लॉ स्टेट के माध्यम से जो है तो लागू होगा. व्हाट इज स्टेट? स्टेट इज एन abstract entity. It is not person. State means the people who compose it. State पे लागू होगा. What does it mean? It will be applied upon the people who compose it. न्यूरेबल ट्रिब्यूनल में आपने यही तो कहा है, स्टेट इज abstract entity. हम रिस्पॉन्डेंट सुपीरियर के सिद्धांत को नहीं मानते. हाँ, एक आगे बढ़ूँ, एक चीज मैं यहाँ और कह देना चाहूँगा कि जब सेकंड वर्ल्ड वॉर खत्म हुआ, दोनों अस्तित्व में आया, तो उसका मकसद था टू सेव द सक्सेसिव जनरेशन फ्रॉम द स्कर्ज ऑफ वॉर. युद्ध की विभीषिका से जमाने को बचाना था, अंतर्राष्ट्रीय शांति व्यवस्था कायम करना था. और जब अंतर्राष्ट्रीय शांति व्यवस्था हो, इसके लिए सबसे सुनहरा मौका किसके लिए होता है? मार्केटाइजेशन, बाजार के लिए होता है. फर्स्ट वर्ल्ड वॉर और सेकंड वर्ल्ड वॉर भी याद कीजिए, दोनों बाजार पर आधिपत्य जमाने के लिए ही हुए थे. और अगर तीसरा विश्व युद्ध दुनिया में हुआ तो बाजार पर आधिपत्य जमाने के लिए ही होगा, जिसकी भूमिका पढ़नी सब तैयार हो गई है, जिसके पृष्ठभूमि में कोविड-19 है, जिसका जिक्र अभी मैं करूंगा. ये बाजार ने गति पकड़ी, अंतरराष्ट्रीय व्यापार होने लगे, अंतरराष्ट्रीय समझौहार होने लगे, अंतरराष्ट्रीय संविधाएं होने लगी, मल्टीनेशनल कंपनीज आने लगी. ऐसी ऐसी कंपनियां जिनका एनुअल बजट भारत सरकार से नहीं जाता, हर देश के साथ ही. मैंने कहा था ना कि विकसित या विकसित विकासशील देश कोई भी हो, सबको एक दूसरे की जरूरत है. कोई माल बना रहा था, कोई खरीदार को चाहिए, तो बाजार का भाव बढ़ता चला गया. और उस बाजार के आने से फायदा हुआ. ऐसा नहीं कि मल्टीनेशनल कंपनी आई तो नुकसान ही नुकसान. देश की कैपिटल बढ़ी, एम्प्लॉयमेंट अपॉर्चुनिटी बढ़ी, लाइफ स्टैंडर्ड बढ़ा, इसको मैं इनकार नहीं करता. लेकिन ये भी सही है कि अब संस्कृति भी बढ़ी, मूल्यों, मान्यताओं, परंपराओं को बड़ा ताक रख दिया गया. औद्योगिक बिजनेस के कंपटीशन के चक्कर में ज्यादा से ज्यादा लाभ कमाने के चक्कर में नैतिक मूल्य, मान्यताओं को या प्राकृतिक नियमों को, प्राकृतिक नियम को बनाए ताक रख दिया गया. उसका दुष्परिणाम भी हुआ. तरह तरह के रोग आए, तरह तरह की व्यवस्थाएं आई. जैसे डेंगू वगैरह के लिए कहा जाता है कि प्राकृतिक पर्यावरण अशुद्ध हो गया था, उससे शुद्ध होने पर हुआ. तो अब वहाँ के स्टूडेंट हो, आप ट्रांसफर ऑफ प्रॉपर्टी एक्ट करते होंगे, उसमें सेक्शन 35 है, जिसमें डॉक्ट्रिन ऑफ इलेक्शन. डॉक्ट्रिन ऑफ इलेक्शन का सीधा सीधा मतलब क्या है कि मीठा मीठा गप, कड़िया कड़िया तू नहीं कर सकती है. अगर मीठा मीठा गप करना है तो कड़िया को भी हजम करना पड़ेगा. ऐसे में इन मल्टीनेशनल कंपनीज के आने से अगर आपने फायदा उठाया है, उससे जो नुकसान हुआ है उसको भी तो स्वीकार करना ही पड़ेगा. लेकिन नुकसान कुछ इस तरह का होगा कि भगदड़ मच जाएगी. नुकसान किस तरह? मैं मानता हूं कि जब मंथन हुआ था, समुद्र मंथन, तो केवल अमृत ही नहीं निकला था, जहर भी निकला था. अमृत पाप देवों ने कर लिया. ये जो इंटरनेशनल ट्रेड है ना, इंटरनेशनल ट्रांसपोर्टेशन है ना, इंटरनेशनल ट्रांसैक्शन है ना, या इंटरनेशनल जितने से व्यवहार है, इंटरनेशनल आवागमन है ना, ये किन लोगों के बीच है? पूरी दुनिया के 15-20% लोगों को. बकिया लोग क्या है? अमृत तो वही पिए, जो जहर उससे निकला आज वो प्रवासी मजदूर पिया, आम जन पिए. वो हवाई जहाज के माध्यम से कहते हैं यात्रा करते हुए कोरोना का वायरस आया हुआ था, जो जन सामान्य कक्षा में है. अभी मैं उन सब बातों पे आता हूँ. यूएनओ बना, यूएनओ ने एक निश्चित उद्देश्य तो बनाए ही. यूएनओ ने सबसे पहले यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट या मानवाधिकारों की सार्वभौमिक घोषणा, सिर्फ मानवाधिकारों का हनन हुआ, मानवता करार होती थी, क्या होती थी. उसी की सुरक्षा संरक्षा के लिए यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट हुआ, जिसमें तमाम देशों ने अपनी भागीदारी सुनिश्चित की और रेटिफाई उनकी विधायिका ने किया। और भी तमाम एजेंसीज बनी, जैसे वर्ल्ड बैंक बना, इंटरनेशनल मॉनेटरी फंड बना, इंटरनेशनल ऑर्गेनाइजेशन बना, यूनेस्को बना, टू सिक्योर द सोशल एंड इकोनॉमिक जस्टिस, वर्ल्ड ट्रेड ऑर्गेनाइजेशन बना टू रेगुलेट द ट्रेड इंटरनेशनली, वर्ल्ड हेल्थ ऑर्गेनाइजेशन बना टू प्रोवाइड द हेल्थ ईच एंड एवरीवन। दुनिया भर की बातें हुई, बड़े बड़े अच्छी अच्छी बातें हैं। और ये जान लो, जो स्पेशलाइज्ड एजेंसीज बनी उसको राज्यों ने अपने स्टैट्यूट लॉ में कन्वर्ट किया। फंडामेंटल राइट या ह्यूमैनिटेरियन लॉ, दे ऑल आर इंट्रोड्यूस्ड इन द इंडियन कॉन्स्टिट्यूशन। भारतीय संविधान के भाग 3 में स्वीकार किया गया। ह्यूमैनिटेरियन लॉ में राज्य और राष्ट्रीय स्तर पर मानवाधिकार आयोग बने। इंटरनेशनल लेबर ऑर्गेनाइजेशन के आधार पर हमारे यहाँ लेबर लॉज बने। वर्ल्ड हेल्थ ऑर्गेनाइजेशन के आधार पर मेडिसिन एंड लॉ बना। बैंकिंग, वर्ल्ड बैंक की रूलिंग के आधार पर बैंकिंग लॉ बना। बल्कि वो जो लॉ तय किए गए थे, इंटरनेशनल लॉ तय किए गए थे, they were adopted by the member states by introducing them in their statutory laws. तो लगा कि स्थिति बहुत बढ़िया है इंटरनेशनल, और ऐसा नहीं कि कोई ये कहता कि हमारा डोमेस्टिक प्रेशर है नहीं लागू होगा, तो इंटरनेशनल लॉ उसमें कन्वर्ट हो गया। अभी एक घटना घटी करा याद कीजिएगा, कोविड 19 का कहर टूटा, सब कुछ बंद हो गया। विद्यालय, विश्वविद्यालय, औषधालय, मद्यालय, देवालय, चिकित्सालय, जितने भी आलय हैं सब के सब बंद हो गए। सभी कारोबार ठप हो गए और इसकी जद में सभी आ गए। अमीर हो, गरीब हो, बड़ा हो, छोटा हो, अधिकारी हो, कर्मचारी हो, स्त्री हो, पुरुष हो, बच्चा हो, बूढ़ा हो, किसी भी जाति, धर्म, लिंग का हो, किसी भी नस्ल का हो, किसी भी देश का हो, कोई फर्क नहीं पड़ता। इक्वलिटी बिफोर द लॉ जो लॉ नहीं ला पाया था, इस डिजीज में इक्वलिटी ला दिया, सबको अपने जज को ले दिया। सभी हाउस अरेस्ट हो गए। लॉकडाउन का नियम सबको सब मानने के लिए बिल्कुल हो गया। सब कुछ बंद हो गया, स्थगित हो गया। मैं इसका जिक्र इसलिए कर रहा हूं, ये स्थगित हुआ। कहते हैं कि 10 करोड़ प्रवासी मजदूर हैं जो अपने जन्मस्थली से दूसरे बड़े बड़े शहरों में गए थे। उत्तर प्रदेश से बताया जाता है कि अकेले बॉम्बे में 80 लाख मजदूर हैं, प्रवासी मजदूर। ये मजदूर को था जो किन्हीं प्रदेश में बड़े औद्योगिक नगरों में काम कर रहे थे, उनके जहन में ही था कि अपने देश में काम कर रहे हैं। कोविड-19 का जब कहर टूटा तो पहली दफे उनको पता चला कि नहीं, ये अपने देश को नहीं काम कर रहे हैं, दूसरे प्रदेश में काम कर रहे हैं। वो भी प्रदेश का उनके सामने यूं आया जैसे वो परदेश में हो, दूसरे देश में। अभी मैंने बताया था कि देश की सीमाएं टूट गई, इंटरडिपेंडेंस का मसला आ गया, सॉवरेनिटी लगभग सीमित हो गई। यहाँ देश में ही कई प्रदेश निकल आए। वो महानगर जहाँ पर उन्होंने अपना श्रम खून बहाया, वो महानगर जहाँ पर उन्होंने सड़कें बनाई, पार्क बनाए, होटल बनाए, मंदिर बनाए, तरह तरह के कंस्ट्रक्शन में जहाँ अपनी पूरा श्रम लगा दिया, मिल फैक्ट्री कारखानों में काम किया, तो एक देश उनके लिए बेगाना हो गया। जिस शहर को खूबसूरत बनाने में उन्होंने सब कुछ कर डाला था, वहीं पर जिस रोजी रोटी के लिए वो गए थे श्रम करने के लिए, उसी रोजी रोटी के लाले पड़ गए। डिटेल में जाकर के मैं कहता हूँ कि झुंड के झुंड पैदल ही हजारों किलोमीटर दूरी तय करने का मकसद ये निकल पड़े। अपने छोटे से बच्चे, माँ बाप, थोड़ी गठरी लिए, थोड़ा सामान लिए, बीवी बच्चों सहित, इसलिए भी जब कोई ठिकाना नहीं रहा, कोई भोजन पानी देने वाला नहीं रहा, जब जान के लागे पड़ गए तो सोचा चलो वही चलते हैं जहाँ जन्म लिया। आप लॉ के स्टूडेंट हैं, आप लॉ पढ़ाते हैं, लॉ जानते हैं। इसलिए मैं आपसे एक प्रश्न करता हूँ, ये जो फंडामेंटल राइट दिया गया है, जो ह्यूमैनिटेरियन लॉ रिकॉग्नाइज्ड है, जो यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट में दिया है, जो भारतीय संविधान में दिया है, क्या whether these rights were suspended or where these rights are suspended during the period 1930? मानवाधिकार सस्पेंड नहीं हुआ है, निलंबित नहीं हुआ है। कोई ऐसी इमरजेंसी नहीं लागू हुई कि मानवाधिकार से, ठीक है हाउस अरेस्ट हमारा है, लेकिन हमारा मानवाधिकार सस्पेंड नहीं हुआ है। आप कहते हो कि पूरी गौरव और गरिमा के साथ लाइफ और लिबर्टी का अधिकार हम आपको देखते हैं, गारंटी दे रहे हैं आप, हमारा फंडामेंटल राइट बता रहे हैं। जीने के अधिकार का क्या मतलब है? किसी तरह से घिसपिट करके जीना। जीने का मतलब होता है शुद्ध हवा, पानी, भरपेट भोजन, निवास की व्यवस्था, न्यूनतम आवश्यकताओं की पूर्ति और निर्भरता के वातावरण में जीना। जीने का मतलब ये होता है। ये हमारा हाई कोर्ट और सुप्रीम कोर्ट, क्षमा कीजिएगा, ये हमारे उत्तर प्रदेश या राष्ट्रीय स्तर के मानवाधिकार आयोग और खासतौर से महिला आयोग से मैं कुछ प्रश्न करना चाहूंगा। कुछ दिन पहले इलाहाबाद में कुछ पोस्टर लगे थे। उस पोस्टर पर लखनऊ में जिन लोगों ने तोड़ फोड़ की थी उनके फोटो दिए हुए थे। इलाहाबाद हाई कोर्ट के कोई न्यायाधीश महोदय हैं, उन्होंने स्वतः संज्ञान देते हुए उत्तर प्रदेश सरकार को जारी कर दिया कि उनके गौरव गरिमा के खिलाफ है, उनके प्राइवेसी में हस्तक्षेप। पूरी दुनिया ने देखा जब वो प्रवासी मजदूर आ रहे थे, एक बैलगाड़ी, उस बैलगाड़ी पे पूरा सामान लगा था, परिवार के 5-7 लोग बैठे हुए थे। एक बैल एक तरफ रुका हुआ था, दूसरी तरफ एक नौजवान था, दूसरे व्यक्ति कमी वो पूरी कर रहा था। कहाँ गई मानव गरिमा, कहा गया मानव गौरव? क्यों नहीं आपने स्वतः संज्ञान दिया? ये कहाँ गए मानवाधिकारवादी? आप तो स्वतः संज्ञान के बड़े आदी बन गए थे ना। आपको उनकी बातें याद आ गई जो कि क्रिमिनल थे, अपराधी थे। उनके गौरव गरिमा की बात याद आ गई, इस श्रमिक के गौरव गरिमा की बात आपको नहीं याद आई। ये वह देश है जहां बाल श्रम शोषण के विरुद्ध बोलने वाले को कौन सा नोबेल प्राइज मिला है। मैंने खुद देखा है सुल्तानपुर की सड़कों पर। मैं कहता हूँ कि ठीक है बॉम्बे से पैदल नहीं आए, झूठ कहा जा रहा है, लेकिन कहीं न कहीं से तो पैदल आ रहे थे। जगदीशपुर जयपुर का भी यहाँ दूर पड़ता है, छोटे छोटे बच्चों के पाँव में छाले पड़ गए थे, रो गए। कहा गए बाल मजदूर के संदर्भ में बात करने वाले? अभी 2 दिन पहले 3 दिन पहले सुप्रीम कोर्ट ने संज्ञान लिया है। 3 दिन पहले सुप्रीम कोर्ट संज्ञान दे रही है। 1.5 महीने से मसला चल रहा है और यही सुप्रीम कोर्ट कहती है कि जस्टिस डिलेड इज जस्टिस डिनाइड। इतना दिन बाद आपको न्याय देने की सुधे आई, और अगर इतना दिन न्याय देने की सुधे आई है तो इतना दिन आप खामोश क्यों रहे? मैंने देखा है, आपने देखा होगा कि 5-6 महिलाओं को जो पंक्तिबद्ध खड़ी थी, एक दरोगा कोई शर्मा है, लाठियों से पीट रहा था उनके पैरों में, कि कहाँ गई महिला आयोग की सम्मानित सदस्याएं? कभी किसी तरह की कोई आवाज उठी ही नहीं। क्या महिला के साथ छेड़खानी करना ही उनके विरुद्ध किया गया आचरण है? अदरवाइज उनको लतियाओ, मारो या पीटो, बड़ी सीलवान है, सब बर्दाश्त कर जाएंगे। या वो ये मजदूर क्लास की थी इसलिए आप लोग नहीं बोले? मैं यहाँ अल्लाह के तौर से बैठे, आप लोग इधर उधर सुन रहे होंगे, लॉ एंड वुमेन भी आप पढ़ाते हैं, वुमेन एंड लॉ, वुमेन एंड चाइल्ड। वो लड़के अगर आपसे क्लासरूम में पूछ लेंगे क्या जवाब देंगे? ठीक है, कोविड-19 के खौफ से इंसान दुबका बैठा हुआ है घर में, निष्क्रिय हो गया है, क्या उसके द्वारा बनाया गया फिर विधान भी निष्प्रभावी हो गया? अब हो भी क्यों न जाए, उसी इंसान का तो बनाया गया है। इंसान को खौफ ज्यादा होते देखा था, संविधान को खौफ ज्यादा होते नहीं देखा। संविधान के पन्नों में फड़फड़ाता रह गया आपका फंडामेंटल राइट। मानवाधिकार की बातें करने वाले अपने बनों में बैठ करके सोशल डिस्टेंसिंग मेंटेन कर रहे होंगे। आप ये बताइए, आपने इतना दिन बाद आपने ठीक है व्यवस्था किया कि ट्रेन जाएगी, ये जाएगा, ये जाएगा। उस ट्रेन को गंतव्य तक पहुंचने में 24-25 घंटे लगते। इस 24-25 घंटे के बीच उनके खाने पीने की कोई व्यवस्था हुई थी क्या? ईमानदारी से बताइएगा, क्या वो भूखे प्यासे नहीं थे? कहाँ गई आपकी मानव दर्जा और माइक्रोलिबर्टी की बात कहाँ गई? क्या ये हद नहीं, हद है कि हद है कि गोरखपुर की ट्रेन उड़ीसा पहुंच जाती है? 24-25 घंटा तो उसने लगाया होगा, फिर 24-25 घंटा आने में लगा होगा। इस बीच खाने पीने की व्यवस्था हुई कि नहीं हुई? और सुप्रीम कोर्ट को परसों ख्याल आ रहा है कि अरे भाई उनके खाने पीने की व्यवस्था कौन कर रहा है? इसलिए आप ला राहुल के बीच बोल रहा हूँ। इसलिए मैं कहता हूँ कि इंटरनेशनल लॉ क्या है ना, अगर वो स्टेचुटरी लॉ में कन्वर्ट हो गया है तो इंटरनेशनल लॉ व्यक्तियों पर ही लागू होगा। उसकी दुर्गत जवाब लोग जो कर रहे हैं, कोई भोला कुछ कहीं भोला। आप तो सब कह सकते हैं मैंने ट्रेन चलवा दिया, आज सुप्रीम कोर्ट कर सकता है, हमने पंजाब में 1-2 महीने आप क्या कर रहे थे? एक अपोजिशन की पार्टी है, उनकी सरकार राजस्थान में है और बॉम्बे में है, पंजाब में। पंजाब, राजस्थान, बॉम्बे से ले आकर के बसें खरीद कर दिया उत्तर प्रदेश के बॉर्डर पे। चलो मैं मान लेता हूँ कि आपकी सब बसें जाएंगी, लेकिन जब उन प्रांतों से आप आ रहे थे, बसों में तेल भराया गया होगा तब वो पहुंची होगी। तो जो इस प्रदेश के प्रवासी मजदूर थे उनको बैठा के क्यों ले जाए? उनको बैठा के ले आके तो उत्तर प्रदेश के चौहदी पे छोड़ दिए होते तो लो भाई अब संभालो, आपके प्रदेश के हैं। तो बात समझ में आप खाली ले आकर के क्यों खड़ा कर दिया? क्यों दिखाए? अमिताभ बच्चन या सोनू सूद कौन है? ये लोग भी बसों से भेज रहे हैं, वही उन्हीं प्रदेशों से भेज रहे हैं, तमाम प्रदेशों से। उन्होंने तो कभी इस तरह की नौकरी नहीं दी। आखिरी आप शुरू कर दिया, पूरा जमाना देख रहा है, इस पर भी राजनीति हो गई। तो सबसे बड़ी बात यह है, देखो मैंने बताया कि तमाम तरह तरह की एजेंसी बनी, संयुक्त राष्ट्र में बड़ा दायित्व संभाला, कहा कि आने वाली इसका से बचाना है। यद्यपि संयुक्त राष्ट्र संघ की स्थापना के बाद 500 के आसपास युद्ध हुए हैं, अभी भी युद्ध जारी है, फिर भी गरीबत है। अभी भी आप मिशन की तरह इसने अपना महत्व नहीं खोया है, लेकिन जो हालात बन रहे हैं जरा, जो स्थितियाँ बन रही हैं, स्थिति एआई की अभी जनरल असेंबली ने अपना एक सेशन बुलाया, एक सत्र बुलाया इसी महीने के पहले हफ्ते के सोमवार को, और 74वां सेशन था। यद्यपि वो सेशन कोरोना डिजीज को ध्यान में रखते हुए समाप्त कर दिया गया, लेकिन कुछ रेजोल्यूशन उन्होंने पाई। अध्यक्ष ने कुछ घोषणाएं की। एक कहा सांस्कृतिक कोऑपरेशन, बताया कि ग्लोबल कोऑपरेशन टू हेस्टेन द रैपिड डेवलपमेंट ऑफ द डिजीज, इस पर प्रयास करना। कहा कि ग्लोबल कोऑपरेशन फॉर मैन्युफैक्चरिंग एंड डिस्ट्रीब्यूशन द डायग्नोस्टिक and the antiviral medicine and the personal protective equipment, manufacturing and distributing the vaccine to fight with the COVID-19 pandemic. रेजोल्यूशन उन्होंने पाया। किसी भी G20 ने along with the World Bank, International Monetary Fund and other agencies to declare the funds should be created in order to support and aid the needful person individually and collectively. World Trade Organization भी थोड़ा कॉन्शियस हुआ उसने कहा कि भाई 38% के आसपास इंटरनेशनल ट्रेड डाउन हुआ है, उसके बारे में सोचा जाना चाहिए। जनरल असेंबली के अध्यक्ष ने ये कहा कि पर्सन अफेक्टेड बाय द कोविड-19 अंडर द ह्यूमैनिटेरियन लॉ require care without discrimination and should be protected against the cruelty and ill treatment. Since health is the social, political, and economic right of each and every man. Social, political, and economic right. This social, political health and the social, political, and economic right has also been recognized by Universal Declaration of Human Rights. Convention on Social, Economic, and Political Treaty, uh, Convention on the right of the protection of the disabled persons, और उन सब का जिक्र अभी थोड़ी देर पहले मैंने किया। वर्ल्ड ट्रेड ऑर्गेनाइजेशन ने इकोनॉमिक प्लेटफॉर्म की बात कही और ये कहा कि हमको मिलजुल करके एक दूसरे को कोऑपरेट करना चाहिए, बिजनेस कहीं समाप्त नहीं होगी। इस समय सबसे बड़ी रिस्पॉन्सिबिलिटी वर्ल्ड हेल्थ ऑर्गेनाइजेशन की बनती है। आप साबित करेंगे कि वर्ल्ड हेल्थ ऑर्गेनाइजेशन की जहां तक व्यवस्था का सवाल है, जब चाइना में शुरुआत हुई कोरोना डिजीज की, लोग चेहरे पे मास्क लगा के टहल रहे थे। वर्ल्ड हेल्थ ऑर्गेनाइजेशन के पास अरबों का फंड है, अरबों डॉलर का फंड है और 5,000 के आसपास अधिकारी और कर्मचारी। आप किस बात के लिए हैं? आपने क्यों नहीं पता किया कि बेग मास्क लगा के क्यों तो टहल रहे हैं? क्या बेग चाइना में लोग जैन धर्म के समर्थक हो गए? ऐसा क्यों हो गया? कुछ न कुछ तो हो रहा है। आपने क्यों नहीं पता किया? वो तो गया भाड़ में। जब अमेरिका में आपको आगाह भी किया कि चाइना ऐसा कुछ कर रहा है, चाइना का ये दोष है कोविड-19 को फैलाने में, तो आपने पहले तो प्रथम दृष्टिया मना कर दिया, नहीं ऐसा कुछ नहीं है। आपने पैंडेमिक इसको, इस रोग को पैंडेमिक घोषित करने में 1.5 महीने लगा दिया। आपने कहा ये एपिडेमिक, ये पैंडेमिक नहीं है। 213 देखते देखते 213 देशों में छा गया है। यानी कि दुनिया में जितने देश हैं सबके वर्ल्ड वाइड इफेक्ट हो गया। और अमेरिका ने जब कहा कि हम अपना फंड बंद कर रहे हैं, और आज 7 बजे सुबह जैसा कि मैंने सुना कि अमेरिका ने अपनी मेंबरशिप वर्ल्ड हेल्थ ऑर्गेनाइजेशन से वापस ली, तब जाकर के आपको ख्याल आया। आपने कहा ये पैंडेमिक। फिर आपने वर्ल्ड ट्रेड ऑर्गेनाइजेशन, वर्ल्ड बैंक वगैरह से मिल करके, ठीक है अभी हम सकते हैं 1 हफ्ता पहले आपके ही वर्ल्ड बैंक के सहयोग से करीब 1 से 60 अरब डॉलर सब देशों को डिस्ट्रीब्यूट किया गया उनकी स्वास्थ्य सेवाओं के लिए। लेकिन एक सवाल यह है कि इस बात का क्या हुआ अगर ये कहा जा रहा है कि अमेरिका के किसी, खाली चाइना के किसी लैब में किसी प्रैक्टिकल के दरमियान, बायोप्रैक्टिकल के दरमियान ये अनसीन वायरस पैदा हुआ, इसकी इंक्वायरी की जाए। क्या आपने कोई कमेटी इसकी बनाई? क्या इंक्वायरी करने के लिए कमेटी बनाई कि क्या वो चाइना गया, क्या चाइना ने क्या उसको कॉपरेट किया, क्या उसकी रिपोर्ट क्या ये आपने जमाने को बताया? जबकि अमेरिका ये कहता है कि चाइना इज अंडर लायबिलिटी टू प्रोवाइड द डेमेजेस, हम वसूल में रहेंगे। केस उन्होंने कर दिया। ये केवल तमाशा है। सिंस इंटरनेशनल कोर्ट ऑफ जस्टिस ने जो कंपल्सरी, अगर हो भी जजमेंट दे भी तो वीटो है चाइना के पास, आप उसको लागू कैसे करें? वो मना कर दे तो आप कैसे लागू करें? ये अमेरिका, इंग्लैंड जितने भी लोग हैं, इन लोगों का सबसे बड़ा दोष है यूएनओ बनाने के बाद भी यूएनओ को कभी मजबूती देने का इनका इरादा नहीं रहा केवल अपनी चौबराट चलाते रहे। जब आप इसके दुष्परिणामों से स्वयं भोगना शुरू किए हैं तो ख्याल आया है कि ये होना चाहिए, वो होना चाहिए। अगर इतना हिसाब था तो आपने इंटरनेशनल ब्यूरो ऑफ इन्वेस्टिगेशन आज तक क्यों नहीं स्थापित? होना चाहिए था कोई इंटरनेशनल ब्यूरो ऑफ इन्वेस्टिगेशन होता जो असेंबली और सिक्योरिटी काउंसिल के दायरे से बाहर होता, जिसको स्वतंत्र अधिकार मिलता कि किसी देश में अगर किसी तरह की कोई इस तरह की हरकतें होती है तो उसको जाए देखे। और दूसरी बात कि चाइना ने अगर किया है, ऐसा हुआ है, इसने केवल सिविल रॉन्ग नहीं किया है। जिस डैमेजेस की बात करें उसने क्राइम भी किया है, क्योंकि लाखों और 60 लाख के आसपास लोगों की जान गई। रोज 1 लाख लोग पीड़ित हो रहे हैं, मर रहे हैं। तो ऐसे में तो कोई ना कोई इंटरनेशनल कोर्ट ऑफ जस्टिस भी होना चाहिए जिसके पास कंपल्सरी जुरिडिक्शन, या इंटरनेशनल कोर्ट ऑफ जस्टिस को ही क्रिमिनल कोर्ट में स्थापित करके इंटरनेशनल कोर्ट ऑफ जस्टिस को ही क्रिमिनल कोर्ट भी बना दीजिए कंपल्सरी जुरिडिक्शन देकर। और ये तब तक नहीं हो सकता जो वीटो आपने 5 लोगों को दे रखा है कि एक आदमी ने वीटो पास कर दिया, सभी रेजोल्यूशन फेल हो गए। कुछ तो संशोधन कर दीजिए कि अगर इन 5 में से 3 एक तरफ हो गए तो रेजोल्यूशन मान्य हो जाएगा। एक की मनमानी चलेगी, अगर मनमानी चलेगी तो चाइना का आप क्या बिगाड़ देंगे? वो कुछ भी करते रहे। आज चाइना कहता है कि ये नेचुरल इवेंट है, प्राकृतिक घटना है। तो कहते हैं कि इतने औद्योगिक इकाइयां इतनी बढ़ गई, प्राकृतिक प्रदूषण इतना हुआ, कार्बन मोनोऑक्साइड वातावरण में इतना फैली, ओजोन परत टूटने लगी, तो ये प्राकृतिक कारणों से रोग पैदा हो गया। चलो यही सही, कर लेने दो इंक्वायरी, इसी लाइन पे कर लिया जाए इंक्वायरी। कुछ तो कीजिए आप। मैं खुद जनरल असेंबली से पूछता हूँ कि आपने 74वां अधिवेशन किया, कुछ रेजोल्यूशन आपने पारित किया, साइंटिफिक कोऑपरेशन, ग्लोबल कोऑपरेशन, फाइनेंशियल कोऑपरेशन, ये होना चाहिए, वो होना चाहिए। आपने कहीं भी ये बात उठाई, इसकी भी इंक्वायरी होनी चाहिए, क्यों हुआ है इसकी भी जांच होनी चाहिए। सिक्योरिटी काउंसिल मानता हूँ कि चाहे मेरे पास वीटो है, कोई प्रस्ताव पारित नहीं होगा, लेकिन इस मसले को सिक्योरिटी काउंसिल की एक भी मीटिंग हुई, एक भी मीटिंग आज तक नहीं हो पाई। ऐसा क्यों है? और अगर इसी तरह से होता रहा जैसे आज अमेरिका ने वर्ल्ड हेल्थ ऑर्गेनाइजेशन की सदस्यता छोड़ी है, कल को यूएनओ से भी कई हम हटते हैं, कहीं यूएनओ का हर्ष कहीं लीग ऑफ नेशन जैसा ही तो नहीं होने जा रहा। अगर ऐसा हुआ तो आने वाला दिन कितना भयावह होगा। मैं मानता हूँ लीगल न सही है, तो नैतिक दबाव ही है तो यूएनओ के नाते। और ऐसा नहीं कि यूएनओ ने कोई रोल नहीं प्ले किया है। आप लोग लॉ के स्टूडेंट है, पढ़े होंगे कि कई अच्छे अच्छे काम भी किए हैं, कई अच्छे मसलों का निपटारा भी उन्होंने किया है। ठीक है, कई जगह असफल हुए हैं लोगों के वीटो के नाते, लेकिन जहाँ वीटो लोगों ने नहीं इस्तेमाल किया है वहाँ पर उन्होंने अपने कार्य में सफल भी हुआ है। सोशियो इकोनॉमिक जस्टिस को काम करने में काफ़ी जैसे पूर्व जैसे रोग को खत्म करने में ऑर्गेनाइजेशन का बड़ा रोल रहा है, सब कुछ रहा है। यद्यपि आज एक बात ये कही जाती है तो 1918 में एक रोग आया था, स्पेनिश फ्लू, 5 करोड़ लोग मरे थे, 3 साल तक उस रोग का प्रभाव था। भारत में 1 करोड़ 12 लाख लोग मारे गए थे। निराला जी की पत्नी उसी मरी थी। महात्मा गांधी स्वयं उससे पीड़ित हुए थे। महात्मा गांधी की बाकी उससे मारी गई थी। 1918 से अब तक लेकर के सैकड़ों साल गुजर गए, आपकी साइंस टेक्नोलॉजी ही नहीं डेवलप की है, आपका मेडिकल साइंस इतना डेवलप कर गया है। उस समय आप असहाय थे, आज भी आप असहाय हैं। ये सबसे पीड़ा का विषय है। आपकी जो स्थिति 1918 में थी वही स्थिति आज भी। क्या यूं कहा जाए कि आपने केवल सामरिक आयुध या गोला बारूद बम ये सब बनाने में अपनी ताकत लगा दी कि किसी क्षेत्र में उतनी ताकत आपने अनुसंधान के बारे में नहीं लगाई, इतना कैपिटल नहीं खर्च किया, इसलिए ऐसा कुछ नहीं। अब कई रोग आज भी लाइलाज बने। और चाइना है, उसकी तरफ लोगों का ध्यान न जाए, उससे कोविड-19 के बारे में बात न की जाए, उसकी कोई इंक्वायरी न की जाए, तो तरह तरह के बहाने ढूंढ रहा है। आप जानते हैं करीब 35-40 चाइना की कंपनियों को अमेरिका ने ब्लैक लिस्टेड कर दिया। तमाम कंपनियां वहां से भाग रही हैं। जापान की कंपनी भी भागी। कुछ न कुछ होया था, चाइना ये न कहता कि भारत इसको अपना अवसर न माने। भारत जो है वो औद्योगिक हब बनने की स्थिति में नहीं है। आज भारतीय सीमाओं पर जो तनाव चाइना पर कर रहा है, तो उसका कारण एक है कि देखो, मैंने कहा ना कि बाजार का वक्त है, कंपनियां भाग रही, तो उनको बाजार चाहिए और उसके लिए भारत तैयार बैठा। ऐसा उसको लगता है, ऐसा उसको दिखता है। वो केवल ये प्रमाणित करना चाहता है कि भारत में हालात अच्छे नहीं, भारत में स्थितियां अच्छी नहीं है। व्यवसाय करने वाला वहीं जाएगा जहां अमन चैन शांति हो। भारत में शांति नहीं है, भारत में अनारकी है। इतना दबाव बनाए रखो कि लोगों को यकीन न होने पाए, लोगों को लगे कि पता नहीं इंडो चाइना वार कब हो जाएगा, ऐसे में उधर जाने से वो अपने को रोके। दूसरी बात है, अभी ट्रंप साहब बार बार कह रहे हैं कि मैं मध्यस्थता करने के लिए तैयार, जबरदस्ती की मध्यस्थता करने के लिए। काहे मध्यस्थता करने के लिए तैयार? एक कदम और आगे बोल गए कि मोदी से मेरी बात हुई। मोदी का विचार चाइना के बारे में ठीक नहीं, और चाइना कह रहा है कि भाई भारत में भी अवसर है, हम मिल बैठ करके तय कर लेंगे कौन कौन होकर। ऐसे में भारत को यहाँ सावधान होना चाहिए। वो कूटनीति से काम को चलाए, कहीं किसी की मंशा भारत के कंधे पे रख करके बंदूक चलाने की तो नहीं। अगर ऐसा हुआ तो भारत रणक्षेत्र बन जाएगा, और मैं जानता हूँ कि मौजूदा नेतृत्व ऐसा होने नहीं देगा। फिलहाल जो हालात पैदा हुए हैं, जिस तरह से अंतर्राष्ट्रीय व्यापार का के ऊपर असर पड़ा है, अंतर्राष्ट्रीय आवागमन वगैरह बाधित हुए हैं, विदेशों से लोग भाग के आए हैं, बड़े बड़े महानगरों से लोग गाँव की तरफ पलायन किए हैं। ऐसा नहीं कि गाँव गुलजार होने जा रहा है, गाँव उजड़ गया था, उस गाँव में लोग लौट के आ रहे हैं, लेकिन गाँव में कोई संसाधन नहीं है। आगे क्या होगा ज्यादा मैं नहीं जानता, लेकिन अभी तो भाव स्वरूप हो सकता है दुर्लभ रूप में वो कुटीर उद्योग, वो मध्यम उद्योग, वो ग्रामीण उद्योग, वो हस्त कला, वो शिल्प कला, जो मल्टीनेशनल कंपनी वगैरह के सामने समाप्त हो गई थी। दिया दिल्ली बनाने वाले वो चाइना के दिया दिल्ली के सामने बेकार महसूस कर रहे थे। तो हो सकता है कि वो सब कुटीर उद्योग पनपने लगे या वो पुनर्जीवित हों, लेकिन उसमें टाइम लगेगा। लेकिन इसमें हम तो इतने से नहीं कर सकते जब व्यवस्था ग्लोबल से लोकल होने जा रही है। ऐसा तो नहीं होगा, क्योंकि ग्लोबल के हम अभ्यस्त हो चुके। ये और बात है कि कोई रास्ता निकलेगा, ग्लोबल हो सकता है, ग्लोबल और लोकल के बीच की व्यवस्था हो सकता है हम ग्लोबल हो, लेकिन जिस तरह से अपने लोकल को इनकार कर दिया था, उस तरह से इनकार करने की पूरा हिम्मत न करें। और इतना मैं जानता हूँ कि 1918 में नहीं, इसकी पहले भी तमाम आपत्ति विज्ञप्ति आई है, लेकिन मानव के पास एक अदम्य चेतना, तो किसी भी विषम विपरीत परिस्थितियों में शिथिल तो हो सकती है, सुषुप्तावस्था में जा सकती है, लेकिन जो ही अनुकूल वातावरण बनता है वो अंकुरित हो जाती है, पवित्र होने लगती है, पुष्पित होने लगती है, अपनी हर जमाने के बीच होने लगती है। इसलिए आज हताश निराश होने की बात नहीं है। और फिलहाल मैं जिन मूल्यों मान्यताओं का हूँ, जिस देश में पला बढ़ा हूँ, जिन परंपराओं का हूँ, उसमें लोग ईश्वर में विश्वास करते हैं, मैं भी विश्वास करता हूँ। लोग प्रकृति के शाश्वत सत्य में विश्वास करते हैं, मैं भी विश्वास करता हूँ। इस बात को तो मानना पड़ेगा, इस प्रकृति के शाश्वत सत्य को स्वीकार करते हुए प्राकृतिक न्याय और प्राकृतिक विधि को ध्यान में रखते हुए। देखिए, हमारा विज्ञान जो बढ़ा वो क्या है? प्रकृति के बाह्य रहस्यों की जानकारी हासिल करना है तो विज्ञान है। जैसे लॉ ऑफ ग्रेविटी है, आपने थोड़े पैदा कर दिया। गुरुत्वाकर्षण का सिद्धांत तो पहले से ही प्रकृति में था, जिज्ञासा आपको जागी, आपने पता कर दिया। ठीक उसी तरह से जितने भी वैज्ञानिक आविष्कार हुए हैं, विकास हुए हैं, वो सब सिद्धांत एवरी एक्शन गिव्स इक्वल एंड अपोजिट रिजल्ट्स। ये क्या है? प्रकृति का नियम है, ये था। तो ये जो कुछ हमने विज्ञान के माध्यम से जाना है, वो सब प्रकृति के बाह्य रहस्यों की जानकारी ही तो है। जैसे आपको बताओ, ट्वाइस एस टू ट्वाइस एस, तो क्या है विज्ञान? साइंस ट्वाइस एस टू प्लस ओ टू इक्वल टू ट्वाइस एस टू, पानी बनता है। ये तो विज्ञान है। और पानी मानव की प्यास हो जाता है, जीव जंतुओं की प्यास हो जाता है, वनस्पतियों को हरिपुमा देता है। ये क्या है? तो जब तक विज्ञान मनुष्य की उपयोगिता की तरफ बढ़ता हुआ विध्वंसकारी प्रवृत्ति की तरफ नहीं मुखातिब होगा, तब तक हम अपने को सुरक्षित मान सकते। लेकिन जब हम सृजन और संहार प्रकृति के दोनों अधिकारों पर अनाधिकार हस्तक्षेप करने लगेंगे, तो कोई अनसीन कोरोना बैक्टीरिया पैदा होगा। ऐसा बैक्टीरिया जो अनसीन है, इनक्योरेबल, ऐसा दुश्मन जो अदृश्य है, लेकिन जिसकी कोई मार नहीं, जो हमको आपको निष्क्रिय किए बैठा गया। प्राकृतिक आपदा भी हो सकती है, प्राकृतिक विपदा भी हो सकती है। क्या आज भी लोग तैयार होंगे? हम अपने औद्योगिक भाषा को थोड़ा तो करेंगे, लेकिन ओजोन जैसे कि बड़ी मात्रा में रिसाव की कीमत पर नहीं, वातावरण में इतना ज़्यादा कार्बन डाइऑक्साइड छोड़ सकते नहीं, वायुमंडल को इतना प्रदूषित करते नहीं, नदियों को इतना गंदा करते नहीं, ग्लेशियर पिघल रहे हैं, गर्मी बढ़ रही है, प्रकृति अपना प्रकोप दिखा रही है। अरे भाई, आप इतना देखिए, हमने तमाम ऐसे रसायन पैदा किए तो उसके नाते तमाम कीट पतंग, तमाम पशु पक्षी इस दुनिया से खत्म हो गए या खत्म होने के करीब। फसलें तो लहराने लगी, लेकिन तमाम जीव जंतु खत्म हो गए, दिखाई नहीं पड़े। तमाम चिड़िया जो चहचहाती थी वो सब खत्म हो गई। क्यों जीव जंतु ही खत्म होते रहेंगे? इन रसायनों का असर जीव जंतुओं पर, इंसान पर नहीं होगा। तो जो खत्म हुए उनको भी किसी तरह की बीमारी हुई होगी। प्याज जो हो रहा है वो भी एक तरह की बीमारी तो है। इसका प्राकृतिक कारण भी हो सकता है, इस बारे में भी हमको सचेत करना चाहिए। और जहाँ तक अमेरिका की बात है, भारत की बात है, तो केवल बाजार पर खर्चे करने की बात है। भारत और चाइना, अमेरिका तड़प रहा है, बाजार उसके हाथ से निकलती चली जा रही है, बेरोजगारी वहाँ चरम पे हो गई है, उसको कुछ हो नहीं रहा है। ऐसे में कोई न कोई ऐसा व्यक्ति या ऐसा देश तलाशना चाह रहा है कि उसको आगे न आना पड़े, बल्कि उसके कंधे पे मजबूत रख करके उसके जो प्रतिनिधि हैं उससे निपटे। इसके लिए भारत को सावधान होना पड़ेगा। इन्हीं शब्दों के साथ अंत में आप सब साथियों को, इन सभी को, जिन लोगों ने मुझे असिस्ट किया, यहाँ डॉक्टर प्रकाश तिवारी, डॉक्टर सुशील कुमार सिंह, निश्चित डॉक्टर वीरेंद्र भरत थे, वो मेरे स्टूडेंट भी रहे हैं, आज भी मुझे याद कर लेते हैं, इसके लिए उनको धन्यवाद देता हुआ। और अभी वो लड़की क्या नाम है, किरण सिंह, जिन्होंने मेरे स्वागत में कुछ बातें कही, धन्यवाद देता हुआ आपको भारत को धन्यवाद।
Thank you, sir. Thank you very much, sir, for enlightening us, for your words of wisdom to our participants. and especially as you mentioned the role of United Nations organs, especially the role of International Court of Justice and Security Council's role, and as well as the role of our uh, lawmaking machinery as well. Dear participants, now we will proceed for the next session for this webinar, which is on topic COVID-19 and international law. Myself, Dr. Prashant Kumar Srivastav, on behalf of Institute of Legal Studies, SHRI RAMSWAROOP Memorial University, extend warm welcome to our learned speaker, Dr. Amrendra Kumar Ajit. He is an experienced assistant professor of Faculty of Law, University of Delhi, having areas of interests in international law, intellectual property rights, law of torts, biotechnology law, and legal research. After completing his LLB and LLM from Banaras Hindu University with UGC Merit Scholarship, Dr. Amrendra has done PhD from National Law University, Odisha, Cuttack, in human gene patenting. Dr. Amrendra has started his academic career in 2007 from Hidayatullah National Law University, Raipur, and in 2010 he joined National Law University, Odisha, Cuttack as an assistant professor and worked till 2018, where he also served as Joint Registrar Academic and Planning. Dr. Amrendra has been a Microsoft Fellow for Summer Institute Training Program in Intellectual Property Rights, organized by Center for Advanced Studies in Innovation and Policy, Law School, University of Washington, Seattle. Dr. Amrendra has participated in various seminars relating to intellectual property rights law, public international law, and constitutional law, and published a considerable number of research papers in reputed law journals. Now, I wish to invite, as participants are eagerly waiting for our learned speaker, so I wish to invite Dr. Amrendra Kumar Ajit to enlighten our participants with his word of wisdom. Sir, please.
Thank you, Prashant ji. So first of all, good afternoon to all participants. And I am very thankful to RAMSWAROOP University and organizing committee member, including Pankaj Agarwal sir, AK Singh sir, Moin Athar sir, Sudhir Kumar, and member of organizing committee, Geetu Singh and all. So today I am going to discuss COVID-19 and its international legal perspective. Something has been already said by Professor Yaswant Singh sir. So I will add something more over that, and I will go through one by one step. That means through PPT. Just I'm sharing my screen. Just a minute. Now I think it is visible. My screen is visible. Prasanji, my screen is visible. Hello. Prasanji, my screen is visible.
Sir, your screen is visible. You can continue, sir.
Yes, yes. Okay. So this type of disease is not first time in history. Okay, this is a kind of zoonosis in which generally disease transfer from animal to human being, and there is a long history of it. Long history of it, and various diseases has emerged through animals. Take the example of chicken pox. Okay, then various kinds of flu, bird flu. Pig was responsible for influenza, and tuberculosis and measles invaded through this cattle. So various kinds of diseases come from animal. But this particular COVID-19 is very specific, especially in the sense that mortality rate is comparatively low in comparison to other uh, epidemic like SARS and Ebola, but its infectious quality is very dangerous in comparison to others. That means it's cause infection with human to human in a very easy way. Okay, it's a very difficult to find out that how you are going to be infected, and within few months, I will say 3-4 months, it has touched 213 countries. So you can imagine this rate of infectious of disease of COVID-19, and this is causing a great concern to humanity itself. Now the today data is approximately 60 million cases have been confirmed till date, out of which 3.64 lakh people has already died worldwide. Okay, so there is a global concern about it when the whole globe is infected with this, and it has so many repercussions also. So there is an unprecedented global impact over all field of human life, and basically it is a kind of threat to the human being itself, humankind itself. Okay, and mostly in case of elderly people, you might be knowing that it is a kind of rate which was never appeared before, like that. Targeting the older people, those who are very vulnerable, they are maximum the mortality rate is coming from that group only. Then it is affecting the global as well as local political system also. At the global level, you know that these days there are so many concern at political level. That means from the China side, from US side, even in European Union itself. Then in case of the local level, even the every state, local government and local people are affected by this pandemic. And more that it affects the sociological concern also. It has been social impact also. You might have seen this migrant issue in India. Okay, then certainly there is an economic loss through unemployment, economic loss due to the lockdown. Psychological effect of this pandemic is too much high, and there is a suicide also to some. I have read 3-4 cases due to this. Okay, and ultimately it is affecting the international trade and business. So if you'll see the impact of this COVID-19, it is a very large impact overall aspect or sphere of the at global level itself, including local level. Okay, so I am going to discuss about this international perspective, and specifically I will deal with 3-4 things, because there is too much broader aspect when we discuss about international legal perspective. Okay, so I am going to focus first of all state responsibility part of the China, that whether China is responsible for this pandemic crisis or not, and if it is yes, then to what extent, and whether liability can be fixed under international law or not. Then if it is yes, then question will be how it can be enforced. If liability is going to be fixed, then how it can be enforced. And another part I will discuss is discuss about the measures taken by international organizations whether these measures are sufficient or there is a requirement of more improvement. Mainly, I will discuss about WHO and UNO, specifically General Assembly and Security Council. And then I will discuss about what next. That means what is happening and what it is required at the next stage. Okay, so first of all, I am going to discuss about the responsibility part of China. Okay, so under international responsibility, and mainly under the category of state responsibility, okay, allegation against the China is that China has suppressed information in initial days. Okay, and it was about 2 months, the first week of November, that they knew something there is about influenza type things, and mainly it was reported on document 17th November. Okay, and China informed WHO on 31st December. So it was already 45 days lost. That means from the first information to the notification to the WHO on 31st December. Then this was the sufficient time to infect the world. And at that time, it has been said that up to January 31st, when China started this lockdown in Wuhan, up to that time, 50 million people has already left the territory of Wuhan. Okay, so they already moved to the different part of the world. So this information was not disclosed on a proper time. Then there is another theory about the bio weapon of China, that China has prepared this virus as a bio weapon, and that was the main, you can say, intention behind to unstable the world economy and get this priority or superior power over world economy itself. So become a superpower, this kind of the things has been done. But question here is because bio weapon theory is will be not valid unless and until there is a concrete proof. So I'm not going to go in that theory or touch that theory part because it is only based on the supposition. So unless and until there will be no proper evidence, any talk will be irrelevant. So just I will concentrate on the part of the state responsibility for the purpose of suppression of information. Then this various case has been filed worldwide, even in the national courts as well as before the Human Rights Council. In national courts and before the Human Rights Council, in UNHRC, case has been filed by International Commission of Jurists, ICJ, not International Court of Justice, International Commission of Jurists, which is based in London, and All India Bar Association, on the basis of carefully assembling bio weapon. Okay, and what was the charge? That for committing a grave offense against humanity by unleashing this COVID-19 to the world, which they have created, Indian Bar Association and International Commission of Jurists, as a biological weapon. Then they are asking compensation, unspecified compensation, causing physical, psychological, economic, social harm to the individual, to the various states, but it is unspecified amount. Then in US, there are so many cases filed, specifically in Missouri and Mississippi states. Okay, that and one out of this, one state government has also filed against China in local court. Okay, so we are going to discuss all these things. So first thing is that what is actually violated by China. Okay, what rules have been violated? So here I am going to discuss that there are both types of, that means treaty obligation as well as customary international law have been violated by China. Treaties obligation and customary international law. So first of all, what kinds of treaty obligation have been violated, which treaty is in issue. So first is responsibility of states for International Wrongful Act 2001. Okay, then international human rights law, then international health regulations, WHO constitution, and UN charter. So now I'm going to discuss one by one. First is international, this responsibility, under responsibility of a state for international wrongful act. Under this, you know that there is a convention on this responsibility of a state for international wrongful act 2001. According to this, a state may be responsible for wrongful act towards international community, and for that purpose there are two essentials. First is that this wrongful act or omission is attributable to the state under international law. First condition. And second is that it constitutes a breach of international law or obligation. So first, it is attributable. That means liability can be fixed to the state when there is a breach of any international regulation. So here this in this case, it is omission of the China. The China has not informed about the pandemic, about the incidents which was occurring at that time within the territory of China, and international community was completely unaware about it. So an omission during the combating the pandemic is attributable to a state. Okay, and international law says that a state has duty to cooperate with other state in case of pandemic. So reporting obligation for infectious disease or its outbreak in the territory of the state is mandatory under international health regulations, IHR. Okay, so there are various claims against China or allegation against China. The first is suppression of information about virus, done very little about containment of these virus within their own territory. Okay, allowed to spread in crucial initial days, and this allows was towards international community. Okay, then till then I told you already 5 million people has already lived to the different part of the world. Then reported to WHO on 31st December, approximately after 6 weeks. Okay, and what has been reported? A pneumonia of unknown cause detected in Wuhan. A kind of pneumonia which is completely unknown, and it was in Wuhan. Then China reported on 15th January to the WHO that there is no human-to-human transmission. Up to 15th January, this is a statement of China, that there is no human-to-human transmission, which was actually known to China that their human-to-human transmission has been already spread. And the doctor who was leading in this case, has been already silenced by the Chinese government. So despite the SARS outbreak, it has failed to take adequately regulation about the wildlife market of Wuhan, that is called wet market. Okay, because SARS was also originated in China, and after SARS also, he has not taken much care about those wet wildlife market of Wuhan city, okay, which is the major source of different kinds of viruses. So provision of this 2001 convention is relevant here within the part 3 of state responsibility. So from article 12 to 15, okay, of state responsibility part, that has been breached by the Chinese government. Okay, so there are so many principles has been laid down from 12 to 15 about the violation of international law. Okay, so under this convention, China is liable for the breach of treaty obligation. Then next is international human rights law. Under international human rights law, the main issue is related to health. Okay, so there are so many human rights involved with this pandemic. So first of all, we are keeping 6 main human rights, which is mainly affected by this COVID-19. First itself is a right to life, then right to health. Third is right to freedom of movement, because there is a lockdown and there is requirement of this isolation. Right to livelihood, freedom of association and assembly, and right to privacy. Okay, and for that purpose, there are various conventions which recognize these as the fundamental rights of human. Okay, and most important article for this purpose is Article 25, Clause 1 of UDHR. Just I will share it. Okay, what Article 25, Clause 7 it says? This one, Article 25, Clause 1. Everyone has right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his control. So if you see Article 25, Clause 1, maximum aspect which is going to be affected by COVID-19 is covered under this. So if China has this not informed properly and it has spread worldwide, okay, and ultimately affecting the rights of individual in this way. So this is a very important article for this purpose. Then various articles of ICCPR, International Convention on this political and civil right, civil and political right. Then International Convention on Economic, Social, and Cultural Rights. Okay, it is right to health, and under ICCPR it is about right to life. Okay, so various provision, just like Article 4 of ICCPR, Article 12 of ECR. Okay, all these are involved under this, and for that purpose there is a violation of fundamental right of human being. But next important source, or you can say breach, is under international health regulations. International health regulations, okay, which is the most contentious part under this COVID-19 debate. That what has been done by the China, what was the obligation of China under international health regulation and WTO constitution. Okay, so it is the most debatable part, regulating about this pandemic. So this law itself has its own history. This was, or is this basic law on which this international health regulation is based, was originated in 1851, and that time it was known as International Sanitary Regulation. Why it was enacted at that time? Mainly due to the cholera epidemics which was happened in Europe in 1935 and 1947. Okay, then after it was continued in that way. When WHO came into existence in 1948, at that time also it was continued up to 1969. And in 22nd World Health Assembly, which is the annual event of WHO. Okay, so in WHO World Health Assembly in 1969, it was properly modified, consolidated, revised, adopted as International Health Regulation 1969. So it is called International Health Regulation 1969, and major amendment has been done in 1995 and 2005. 2005 amendment was specifically done after this SARS outbreak. Okay, so this is now called as International Health Regulation with new amendments of 2005. In this, there are 196 countries of the world. WHO, 194 countries of the world. Okay, so two countries, Liechtenstein and Holy See, they are two additional member under this International Health Regulation. Those who are not the member of WHO. Okay, so what is the purpose of IHR? Okay, so purpose of IHR is to prevent, protect against, and control, and provide a public health response to international spread of disease. So it is mainly about the containment of regulation about prohibition of this protection of about this disease. Okay, and mainly it concerned for the epidemics. So just I will come because the main law for which the China is responsible is under international health regulations. Okay. So what are law violated under this? The main law violated under this is first Article 3 itself. It is about principle. What are the principle for this containment or this disease and pandemic? It said that implementation of these regulations shall be with full respect to dignity, human rights, and fundamental freedom of person. And this implementation of these regulations shall be guided by the Charter of the UN and World Health Organization. So these are first two principles within the Article 3, which talks about that regulation is first of all will be implemented with the human dignity, human rights, and fundamental freedom of person, and China is a party to it. Okay, and implementation of regulations will be in accordance with the UN Charter and WHO Constitution. Then next is under which it is directly responsible. Directly responsible is under Article 6. Okay, this notification. And this Article 7 and Article 6, both these 6 and 7 articles, okay, is under which China is responsible under international law. It is a directly related with the omission of the China. Under 96, it has been said that, okay, under 6, it has been said that each party will notify public health emergency of international concern. Public health emergency of international concern, PHEIC, fake. Okay. So this must be notified within the 24 hours, within the 20, just I will increase the size, within 24 hours of assessment of public health information. That means once the information will come to the local authorities, and that means came to the local authorities of China, so within 24 hours, it must be communicated to the regional office or local office of WHO, or directly it may be communicated. Okay, Article 6. Then it is about Article 7. Information sharing during the unexpected and unusual public health events. So every state who are the party of it, this regulations, if they are getting the evidence of unexpected and unusual public health, which was already started from the November 17th within the territory of Wuhan, okay, irrespective of the origin or source, may be constituted a public health emergency of international concern. It shall provide to WHO all relevant public health information, okay, and in such a case, the provision of Article 6 shall apply in full. That means now China was under international obligation to communicate to the, first of all, WHO local office. Once they knew that something is like influenza-like symptoms happening and source is not known, and then all the information related to patients and all must have been communicated, but it was not done. Okay, so question here will be that China, this omission of China, how it can be fixed. Then within this regulation itself, there is another provision about the emergency committee. Emergency committee under part 9, article 48. Okay, so this role of emergency committee I will come later when I will discuss the WHO part. Okay, that means just you remember that this emergency committee is under article 48 within chapter 9 itself, which is also responsible. This emergency committee, article 48, terms of reference and compositions. Okay, so it has a very crucial role under WHO itself. Okay, and this is the advisory committee to the Director General of WHO. So I will come later on when I will discuss the WHO, but just you know that there is an emergency committee within the International Health Regulation 2005 itself under article 48. Okay, so these are the main breach of obligation under international health regulations. Then next point is about WTO constitution. That what has been violated under the WTO constitution. So under the WTO constitution itself, the main, because China is a party to it, the preamble itself suggests, okay, that because it is a specialized agency of UNO, WHO, and a specialized agency work with UN, okay, on a specific issues. So question here was about the working for enjoyment of the highest attainable health or a standard of health. So these principle of WHO preamble, principle 2 and 3, it has been said that the state parties of this constitution in conformity with the Charter of the United Nations and following principle are the basic principle of this. So these two principles, principle number 2 and 3 here, the enjoyment of highest attainable standard of health is one of the fundamental right of every human being without distinction of race, religion, political belief, economic and social condition. So it is the duty of every state to provide that highest attainable standard of health. What has happened? China has spread this disease without taking the distinction of any race, religion, political belief, economic and social condition. That means China has affected the European countries also, African countries also, and it is because it is a source of origin itself. Something will be not controlled at the origin itself, so certainly it is going to be deadly for the world. And the same thing was happened here. Then third principle of this preamble says that health of all people is fundamental to attainment of peace and security. And this is in consonance with the UN Charter. Okay, health of all people is fundamental to the attainment of peace and security. So international peace and security is the main objective of UN Charter also. Okay, so here under WHO, health is a specific issue for the attainment of peace and security, and it is dependent upon the fullest cooperation of individual and states. So unless and until states will not cooperate on a particular health issues, then there will be no attainment of peace and security, and which is directly under breach of the international law here by China or Chinese government. Okay, so this is the breach of international obligation under WHO. So China violated the core objective and basic principle of WHO constitution. Then if I go to the UN Charter, so within UN Charter itself, you know that the basic purpose of UN Charter is to maintenance of international peace and security. And now you can see that what kinds of this international peace and security is worldwide. Okay, that it is completely, world is completely now in a position of lockdown. Economic and trade is completely at the minimum level. Okay, growth are going negative. Okay, certainly there is a tension between these two superpower. Even in Security Council, there is no harmony, and you can say there is no consensus. So this has led to the threat to international peace and security. In that way, it is the violation of the UN Charter also. Next thing is about violation of customary principle of international law. Okay. Under customary principle of international law, China has violated mainly three principles: provision of transboundary harm, duty of due diligence and due care, and duty to cooperate. So first about provision of transboundary harm. Okay. So provision of transboundary harm is not a new principle. It is now properly established principle, and it is a general principle of international law, even under the conventional and treaties, and under the customary international law also. Okay. So these customary international law has become the part of the treaties laws also. So principle has been accepted. This principle has been accepted under the Rio Declaration on Environmental and Development, principle number 2, which talks about any state cannot create or cause a harm to any other state from which is happening within his territory. Okay, so for that purpose, that state will be responsible. So there should not be transboundary harm. And the same has been conferred by International Court of Justice in its advisory opinion on the legality of threat or use of nuclear weapon. Okay, that there must be a kind of separation. You can say that state will have to take responsibility that if his act or his agent's act is causing any kind of threat to a member of any world community, then in that case, that state will be responsible. The same thing was also highlighted in Trier Smelter case. It is a very leading case, arbitration case between Canada and USA, under which the award was that Canada was responsible for that because the smelter which was causing a pollution to the river and forest area of USA, okay, that was that Canada was responsible for the compensation and reparation. So that established principle. Then again, it was accepted as a principle 21 under a Stockholm Declaration. So this is the established principle. Here what happened, that due to the negligence or omission, okay, or here it is not negligence, it is omission, that something was new to the government and deliberately it was not disclosed. In that case, this is a kind of omission, and due to this omission, there was a transboundary harm and global harm. Now 213 states are, if you will exclude the China, then 212 states are under this disease. Duty of due diligence and due care. This is also established principle of customary international law. Duty of due diligence. Okay, it is a duty of due diligence about what? It is about the standard conduct of a state. That if situation has been arisen, okay, then what kind of act is required from the state. So there must be a due care and due diligence on the part of the affected state, that what kind of action he may take, and that should be taken through due diligence. It is a very old principle of municipal law also. Okay, and it has been established under this principle of international law, and it has been recognized long back in curfew channel case. Okay, so under curfew channel case, ICJ has said that states, that Albania was responsible, that he has not done anything, but there was mines below the sea. Okay, and due to that there was a damage to the British ship, and it was within the territorial sea of the Albania. But Albania, it was not proved that all these things have been done by Albania, but because it was within the territorial sea of Albania, Albania has not taken any action. It was not informed to the ship coming to those territorial sea. Okay, in that case, it was an omission on the part of Albania, and for that purpose, Albania is responsible. Okay. So this is a very old principle established in 1947 and 1948 itself. by ICJ. Okay, so here also the state China has not taken care of the due diligence or due care about non-spread of the disease, that it should not go to beyond the Wuhan. And you may see that even in China itself, it was only concentrated within Wuhan. Okay, not has spread a other part of the country, but it has spread worldwide. So that is also a kind of things that it was deliberately not controlled, that it was going to outside of the China and affected the European country, American countries. Okay, and now it is worldwide. Then this is last is duty to cooperate. This duty to cooperate is also principle of international law, customary principle of international law, and it is coming under general principle of international law. Okay, for that purpose, it is under principle 24 of the Stockholm Declaration 1972 and principle 7, 40, 14, 27 of Rio Declaration 1992. So duty to cooperate, and this all of these principle is mainly related to international law and specifically about international environmental law. Okay, that means causing harm to the other states. So China has breached treaty laws as well as this international law under customary international law. Then next is about role of WHO. Sorry, I think it is about enforcement. Yes. Next is about enforcement. So when we talk about enforcement, that how it can be enforced, an entity may be responsible legally under international law, but international community might not be able to impose legal consequences. And here you will see that the main nature generally we discuss under the first module of international law paper itself, nature of international law. Okay, so this is reflecting here. And whenever there is a crisis between the major power states, okay, certainly the nature of international law comes into picture. And here now, because China is involved, okay, so enforcement is also to some extent technical. So question here will be how it can be enforced, because now these are the breach under different legal obligations under treaties and customary international law. So what should be the forum? So forum may be ICJ, ICC, International Court of Justice, International Criminal Court, Security Council, arbitration, national courts. Okay, so when we discuss about ICJ, okay, so ICJ, how it can take action? Under ICC or ICJ, there is a requirement of credible obligation, and you will have to prove that. Okay, and for that credible this obligation, an alleged omission, which is under IHR, International Health Regulations. Okay, for proving China into that, okay, and to acquire the jurisdiction of ICJ, there must be consent of China. So just as it was told by Professor Yaswant sir, that ICJ is based on this consent agreement. There is no compulsory jurisdiction in a way that even without the consent of a state, ICJ may intervene. This is not a procedure under ICJ. Okay, so it is completely futile because China is not going to give permission or consent to accept the jurisdiction of ICJ. Then next is, when you are going to prove this, there must be requirement of establishment of causation. And how you will establish the causation? That China was wrong, because it is the assumption that China has not given information at the proper time and that time was left. But whether the China was really knowing about the virus or knowing about the symptom, okay, all these things should be proved, and that kind of evidence will come only after inquiry. So question here will be, who will do the inquiry? Is there, sir has told already, that is there any international investigation agency? No. So who will give the consent? China is going to give the consent that, okay, there must be inquiry because US is asking for the inquiry. But China is not ready for that. Okay. So who will do the inquiry, proper inquiry? And it must be established, not only the inquiry, it must be established properly. So under WHO, it is a provision that WHO Health Assembly may send the dispute to ICJ. Okay. But ICJ will give decision only for the breach of WHO constitution obligation. Okay, breach of obligation which is mentioned in WHO, just we have discussed about principle 2 and principle 3. Okay, not beyond that. Then other assumption is under ICC, International Criminal Court. Can Jinping be charged for genocide? Because there is more than 3 lakhs death worldwide. Okay, so question here will be whether Jinping will be responsible for genocide. And China alleged omission will come under genocide. That means this alleged omission not to inform to the WHO on proper time will amount as a genocide. So certainly it will not come under that category. That non-information will result into genocide and person will be responsible for that. It will not come under that. Second important thing is that US and China both are not the party to the International Criminal Court. Okay. So for non-state member, it will be very difficult or impossible to plead the jurisdiction of ICC. Okay. So even preliminary inquiry, which is generally done by the prosecutor of ICC, cannot be done against the China. Because they are not, these two are not the member. China is not a member of ICC. So the prosecutor under ICC cannot do any preliminary inquiry against the China. So matter will not go to the ICC also. Next is Security Council. Okay. And you know the basis of Security Council. That within Security Council there is one more important, or you can say now this is futile exercise of the veto. Okay, because when these country will be involved in any issues, then anyone may impose veto over the decision of ICC. Decision of Security Council. So Security Council is not remain a legal body; it is completely a political body. And this political body take decision according to international politics, their claim, okay, their pros and cons. So you cannot see that you will get the justice from Security Council. Okay, because it is only the balance of interest within that council. So there is no fixation, no scope for fixation of liability even within the Security Council, because whenever it will be against China, China will come with veto. China is coming with a veto for the Pakistan. Why he will not come with for one reason? Okay, so this is also a complete failure. Then arbitration under WHO itself. Okay, WHO Constitution and IHR, International Health Regulation. But this arbitration also require this consent of the other party, respondent party. So China is not going to give the consent for the arbitration. If it will, they will give, then it is okay. But attitude of the China is that it is not going to give any consent for the arbitration also. So this is also not possible. And last is national courts. Okay, and national courts is with these cases mainly in USA these days. So under national courts, any foreign state have a sovereign immunity. And this is the basic principle of international law. So in national court, action of foreign state cannot be charged. And if it is going to be charged, and if it is going to be accepted by other, then certainly it will be a kind of Pandora box, opening a Pandora box, that all states will sue within national court against all other states. Okay. And what will happen? That it is only the wastage of the taxpayer money of that particular country. So it is the balanced approach in international law itself that foreign state will get immunity in the national courts. Okay, so certainly what US is doing, it is not going to result into a conclusion. And US, generally for US, it is said that in US there is a phrase, I shall sue you. Okay, they believe in suing others, but they want protection for themselves. They should not be sued in any court of the world, but they can sue any country, any person within the USA. So without reciprocity, it cannot happen. Okay, and this reciprocity will be against the established principle of international law. So in that case, national court, this jurisdiction will be also futile. So overall, if you will see that it is very difficult to bring China under the enforcement procedure under international law. And here you will find that international law is a soft law. Okay, international law is a weak law. Once the big parties are involved under international law, certainly nature of international law generally comes into picture. Then next important is role of WHO and its liability. Is WHO completely dependent on state information to act promptly? This is the question. Okay, and then design problem within the international health regulations itself. Okay, and then emergency committee meeting, which I told you earlier. So now question is this: to what extent WHO is responsible? Under WHO, there is a procedure. Okay, under WHO there is a procedure. Procedure of what kind? That in this IHR, that rule is that WHO may get information from media, from newspaper, from social sites. Okay, all these are available for the WHO. But question here is, has WTO taken any action for that? WTO has gathered any information, whether the matter was available to the WTO. This is also important factor. Okay, so WTO can take cognizance from non-state sources, but non-state sources information will come into what? In newspaper, on internet. But you know that China has a full control over their all kinds of media. Okay, so when nothing can come to the media, then how the WHO will take that? Because WHO has duty that to take those information from media, analyze it, ask from the government, that state government, whether this is true. And if that state government is not giving any answer or not willing to reply, even that, in that case, WHO can go against the will of that particular state and put a notice on its own website. Okay, that particular things is happening in that particular area, and world should be careful about that. Okay, it cannot happen in case of China, because China has a full control over the media. So nothing came in the media report. So at that stage itself, WHO was not responsible. Okay, then something problem is in IHR rules itself, International Health Regulation rules itself. What are those? That is public health emergency of international concern. Okay, now I am coming to this Article 12. Article 12 of IHR talks about the determination of this public health emergency of international concern. How to determine that this is the PHEC, public health emergency of international concern. So for that purpose, there is a rule under international health regulation itself, that emergency committee, which is constituted under Article 48 of this IHR, will give report to the Director General of WHO, and the Director General WHO can take this action. But once you will go in the definition part of public health emergency of international concern, then you will find that there are three essentials. What are those three essentials? Extraordinary nature of, just I will show you this. Public health emergency of international concern. Okay, so means an extraordinary event. The first is essentially extraordinary event which is determined as provided in the regulation first to constitute a public health risk. Second one, and third is potentially require a coordinated international response. So these three essential extraordinary nature of event, who will determine? Then public health at risk, it may be to some extent, okay, objective, and potentially require a coordinated international response. Okay, so it has been said that these three essential are mainly ambiguous in nature. Okay, and it is very difficult to determine, and this generally led to the create a problem for this emergency committee. But question here was that once this information was notified by the China on 31st December 2019, okay, then the first emergency committee meeting was happened on 22nd January. So it was approximately after 3 weeks. Okay, so question here was that after notification, why 3 weeks was taken by the WHO? Okay, this is not a reasonable period. It would, that means WHO might have acted prior to that. After first meeting, Director General visited China, okay, on 20th January, and then there was a second meeting on 30th. Okay, and in second meeting, certain guidelines was given that what emergency committee given the guideline. Question here was that whether the decision or advice of emergency committee is binding in nature. No. Emergency committee is only advisory in nature. And when this kind of emergency is there, in that case, Director General should not take too much time to call emergency committee meeting, or director would have decided the case independently because it is advisory in nature. So it is not binding. Director General is independent to take decision. Okay, but Director General has not taken a proper decision and shifted this burden on emergency committee. In first, on 30th January, there was a second this emergency committee meeting, and in 30th January, the international guideline was issued. But what happened? Before 30th January, various states has already taken action on their own after seeing the media reports and rate of infection of the disease. So here you see this is the failure on the part of the WHO itself, that not inform the world community properly on a proper time. Okay, then WHO alert system has been completely failed in initial days in this COVID-19. Okay, which is required under this alert system is requirement under IHR and WHO. Next is about United Nations. Okay. Role of United Nations. So pandemic is testing the limits of multilateral system of the world, and specifically about the United Nations. And it has been said by Secretary General of UN, Antonio Guterres, that most important, this is the COVID-19, the most important challenge in the history of UN and after Second World War. Okay. And General Assembly, you know that General Assembly resolution is not binding in nature. So this General Assembly has taken two main resolutions, mainly about the global solidarity to fight coronavirus on 2nd April and 20th April about the resolution on coordinated effort for vaccine, medicine, and PPE kits. So it is only about not the responsibility, not the fixation, or not proving a guilty against anyone, only to fight the corona in a proper way. Okay, so and it is this was unanimously passed. Main is about Security Council resolution. Okay. What Security Council is doing? It is the main forum of global security governance in the world. Okay, and health has been the rare subject matter for the discussion before Security Council. But Security Council has discussed health issues earlier 3 times in case of AIDS, SARS, and Ebola. And there is a proper discussion and a resolution to take action against these epidemics. But there is no coherent approach within the Security Council itself on the issue of COVID-19. Okay, so it is presently just like incapable to do something. It is de facto incapable to do something about the COVID-19. Member of Security Council is bickering among each other. They are going against each other, blaming. You know that US and China is they are very busy in blame game. Okay, President Trump has given so many statements against China. China is defending that he is not responsible for all this. Okay, and these permanent member, 5 permanent member, covering the 30% cases, 30% of global is total cases of the globe of COVID-19. But even then, they are not keen to solve the issue, to coordinate on that issue of COVID. So Security Council is not playing, or you can say silent completely on this issue. Okay. So question here will be, what next? What next? Next is, that means what it can be done. So first of all, there is a requirement of IH amendment itself. Again, there should be proper mechanism for the alert system. Alert system should be properly developed. System should complete the assessment, monitor, and ring the bell early, not wait for 3 weeks or 4 weeks to decide the case. Not decide this, just doing the meeting only. Okay, and there must be a proper forum within the IHR itself, which will coordinate in case of any pandemic or epidemic at the very early stage itself. It should not be self-dependent, but there must be a kind of this coordinated effort within member state itself. So there should be a proper forum for coordinating about the effect of pandemic in the very early stage itself. So there should be less loss of life and money and time and all. Then duty of Security Council these days should be that their Security Council should act under the more greater international cooperation. Okay, and only this global cooperation will fight against the COVID-19, because it has been said that isolation is not going to work at all. There was no such kind of the transportation in the 20th century during the 1920 plague and all. Prior to that, during medieval period and dark period of Europe, there were so many this kind of pandemic. There is no such kind of the globalization concept at all. But even though disease has spread from one part of the another part of the globe, okay, so isolation is not a meaning to deal with this. Certainly, there is a requirement of global cooperation amongst the state itself on every level itself. Allegation and claims between the member state only escalate the issues without solving the present crisis. Okay, so there is a requirement of more global solidarity at this time. Even at the level of Security Council, at the outside the Security Council also, at the global level, and at least at presently when the disease in present, there should not be blame game. Even against the China also. Everything can be settled after this pandemic. But during the pandemic, because this is the crisis period, and during the crisis period, there should not be that kind of the this debate of who is responsible, who is not responsible, and what is the claim. All these things can be sorted out later on. And in this way, we can see that next few months, that means up to the end of 2020, it is a very decisive month to come in nearby, which will set a new geopolitical order in this globe. Okay, and how it will work, no one is knowing. How it will go on. Okay, where there will be the all these things against the China, US, EU, how they are going to work, how things will change, no one can predict. So these few months they are very precious, you can say, are very decisive for the world history of 21st century. But at the end, I will say that what should be the major concern here is that has been already told by the sir also, this one sir, that now world should focus on environmental law and climate law, harm to the human life. So first of all, protect the environment, give the proper respect to the environment, take the this effect of the climate change, that there should be minimum climate change. There should not be transgression of any virus from animal to the human being. And for that, unless and until we are not going to protect the environment, it will not decrease in future. Okay, because you have seen that what was the rate of transgression from animal to human, these viruses, now this has been increased in 21st century. 3-4 attack we have already seen after 2000 itself. Okay, so for that purpose, there is a requirement of taking the proper care of environment. In larger perspective, I want to say. So this is all about the international legal dimension of COVID. I have tried to cover 3-4 major things. Otherwise, there are so many things under the legal perspective of COVID. Okay, so thank you very much.
Thank you so much, sir. Hello, sir. Thank you so much, sir, for your valuable insights. The team ILS is very much grateful to you as you spared an hour for us and delivered the lecture, which could be useful for the students as well as the academicians. Thanks a lot, sir. Sir, due to strict time constraints, we would be taking only a few questions. Okay, sir. So the first question is from Sir, the first question is from Mr. Sarvesh Kumar Shahi, Assistant Professor Law, KIT Bhubaneswar. Sir, are you expecting any international any changes in the international legal scenario due to this COVID-19?
Yes, that means change in international legal scenario. This is the question.
Yes, sir.
Okay.
Yes, sir.
Now, Italy, the world is under the completely unprecedented stage. Okay, and how these major powers are going to work. Okay, how this is going to affect in future. Certainly, something is going to change, but to what extent it is going to change, no one can predict till now. Okay, but world is not going to remain as it was pre-COVID, even in the international legal system also. Something will change because going to bear this kind of the loss due to the existence legal system. There will be major improvement, but what kind of will come, I think it will take 3-4 years to see.
Okay, thank you so much, sir. So the next question is from Sarthak Divedi. So he is asking that you please highlight the term bioterrorism and what is its significance with respect to China?
bioterrorism means when you are, first of all, definition of terrorism is so much not still yet fixed. But anyway, if you are able to cause terrorism with the bio life, that means microbiome or any kind of this microorganism, okay, then it coming under the category of terrorism, which is the threat of humankind itself. Under the bioterrorism thing is that it is invisible, okay, and the loss is many times in comparison to the actual war. First, second thing is that in this China is known for it. Because in the Wuhan itself, there is a this biological laboratory which is claimed to be they are working since 30 years on these kind of the molecules of life science. Okay, so it is not clear yet that it is this biological weapon, because China is not ready to for this inquiry. But if it is going to be proved, if it is going to be proved, then it may work. Otherwise, world is heading towards the bioterrorism. Okay, and particularly in these states where the autocratic states, they are not democratic states. So in these kinds of state, threat is more. Just like in the take the example of North Korea, even in China, okay, to some extent Russia. So there you can concentrated the biomass weapons in their own territory. There are international conventions, but when the war will happen, no one is knowing that how they are going to react, how they are going to use it. Okay, so certainly in near future, if something will happen, bio weapon will be one of the important tool for a war. Okay.
Okay, thank you, sir. Sir, one last question. Sir, this last question is Riya Shukla. She wants to ask that, sir, recently WHO has passed a statement that the virus does not travel from one person to another. So don't you think that this statement amounts to willful carelessness?
No, WHO has passed but what is the date? Because earlier it was communicated by the China to WHO, but earlier it was, I think now it is completely proved that it is human to human contact spreading. Okay, just I will have to see that what is the date for that.
But being an international organization,
certainly international. True. Certainly, WHO has taken so many bad name for this COVID this time. Okay, and after that, so many statements have been passed. So, first of all, there must be a proper investigation, because WTO is completely dependent upon the this budget of the USA. Okay, you know that WTO budget is $4 billion, where the National Health Institute budget is $10 billion of USA. So hardly 40% of the National Health Institute of this. So unless and until you are not going to give it to the WHO, just is a recommendatory body and not because they are also dependent upon the member of the CDC. CDC, you know that this is the committee in the US government. So the voluntary member of the CDC work for WHO. Okay, and if they are voluntary to work for the investigation purpose and all, then WHO will get this report and all. So WTO is also dependent upon the other bodies. So they are mainly regulatory, but if they are giving this kind of the statement, certainly it is a clear statement, it should not be given. But I will have to check that what is the date of this statement, because if it were having in the initial days up to the January itself, then it may be the kind of the things that which has not been to the WHO properly, but now it is properly established that it is spreading through human to human.
Thank you so much, sir. Sir, now I would like to call Dr. Sudhir Awasthi, sir, Associate Professor and Dean, Institute of Legal Studies, SHRI RAMSWAROOP Memorial University, to express his gratitude. Thank you, sir.
Thank you, sir. It's my privileged to propose a vote of thanks on this occasion. I, on behalf of Institute of Legal History, Sri Ramswaroop Memorial University, would like to extend my heartfelt thanks to all who have helped us in making this webinar such a resounding success. First of all, I would like to propose hearty vote of thanks to our speaker, Professor Dr. Yaswant Singh sir, for gracing today's webinar. Thank you so much, sir, for your interesting and thoughtful views. I would like to thanks our distinguished speaker, Dr. Amrinder Kumar Aji, for making excellent presentation and making this webinar meaningful and interesting. I would like to express our profound gratitude to our director, sir, for his blessings and support in making this webinar success every day. Finally, the wonderful participants who have turned up in such great numbers, not only from our university but also whole India and other countries, whole India and countries. For thank you so much for your participation. As no program can become successful with a single person. So I extend my big thanks to our faculty members for their cooperation and support. This event wouldn't have been successful without the students. Thank you so much, my dear students. Once again, I thank all for your cordial cooperation. Thank you, sir. Thank you very much.
Thank you, Sri sir. I would hope today's session would definitely be beneficial for the student, academician, research scholar in your future endeavors. Again, we'll meet tomorrow on the third day of the webinar on impact of COVID-19 on law and society. All the participants are requested to be available on time, that is 11 a.m. sharp. Tomorrow session would be again be meaningful, as tomorrow we will be having three speakers with us, which will be sharing their views on the relevant seminar which is going on.